called to order. May I ask everyone to stand and remain standing through the invocation and the U.S. and Texas pledges. You may be seated. Let me recognize the Nacogdoches County Sheriff's Office, Lieutenant Cody Pierce, Sergeant Mario Reyna, Sergeant Hannah Reyna, Sergeant Kylie Parker, and Captain Roy Mobley. I also want to thank my colleagues, Commissioner Griffiths for the invocation and Commissioner West for leading us in the pledges this morning or this afternoon. So anyway, Melissa, can you please do roll call for us?
Commissioner Kim Lamo.
Here.
Commissioner Jason Hester. Commissioner Justin West.
Here.
Commissioner Patricia Burris.
Present.
Commissioner Jana Atkins, Commissioner Michael Griffith,
Here.
Commissioner Justin Berry,
Here.
Commissioner Connor Harvey,
Here.
Commissioner Sergio Sines. We have a quorum.
Thank you very much. Well, I want to thank everyone who has joined us here in Nacogdoches this afternoon. Again, this is part of our commitment to our community to come to you and not just ask you to come to Austin to meetings. So we've made the commitment to be here with you today. I want to thank you for your hospitality and for your presence here today. And for those of you that are joining us online, thank you also for being with us this afternoon. We are here, like I said, in Nacogdoches, beautiful, I guess it's still fall, beautiful fall day out here in East Texas. So thank you for gracing us with some beautiful weather. This afternoon had a nice drive in, got to see a little bit of Texas color. So very nice day so far. So thank you for having us out here. We are, for those of you that are joining us either in person or online, let me go ahead and explain the schedule a little bit to you today. Oftentimes we just have the commission meeting, which are typically on Thursday. Sometimes we will hold a workshop, and those are oftentimes held on Wednesday afternoons. But we had a lot of material to cover in this meeting, so instead of having a full day meeting and have that potentially go for 6, 8, 10 hours in one shot, or trying to do a workshop and have a longer meeting, we opted to go ahead and split the meeting in two. So we are meeting this morning. We will convene again tomorrow at 9 o'clock, same place, and really have part two of our commission meeting. We're not having a workshop this time around, but like I said, we have a lot of material to cover, and we'll be splitting it half today and half tomorrow morning. So especially for those of you, I know we have a lot of folks that join us online either in the moment or you go back and review the video. Please make sure to note that this meeting is split in two. So we'll have this afternoon and we'll have the meeting again tomorrow morning. So thank you for that. We're going to move to agenda item number 4. And that is the approval of the minutes from the September 3rd workshop and the September 4th commission meeting. Do we have a motion?
Make a motion that we move and accept the minutes from last meeting.
We have a motion. Do we have a second? Second. We have a motion and a second. All those in favor say aye.
Aye.
Aye. Any opposed, same sign. Motion passes. We will be going to agenda item number 5 next, which is discuss and take action on proceedings for revocation, suspension, and other disciplinary actions. And who? Okay. Aaron, I believe you will be representing TCOLE.
That's correct. I'll be starting us off today. Good afternoon. The first 3 cases we have are defaults, and these are situations where petitions were sent to the appropriate address and were not responded to in a timely manner. First, we have Antonio Bonilla Jr. He was convicted or placed on community supervision for driving while intoxicated, a Class B misdemeanor. He failed to answer the petition, and the executive director recommends a 10-year suspension for your consideration.
I'll make a motion that we move to accept the default suspension order for Antonio Bonilla Jr.
Second.
We have a motion and we have a second. All those in favor say aye.
Aye.
Any opposed, same sign. Motion passes.
Next, we have Cody H. Thomas. He was convicted or placed on community supervision for assault, bodily injury, married, a Class A misdemeanor offense involving family violence. Respondent failed to answer the petition, and the executive director recommends the revocation of respondent's license for your consideration.
I make a motion that we move and accept the revocation of the license for Cody Thomas.
We have a motion and a second, Any other questions or discussion? Okay. All those in favor say aye.
Aye.
Aye. Any opposed, same sign. Motion passes.
Next, we have Bryce A. Reed. Respondent's Academy removed him from the report of training for the basic peace officer course for cheating, and respondent compromised the integrity of the state licensing exam. He failed to answer the petition, and the executive director recommends the cancellation of respondent's license for your consideration.
I make a motion that we move and accept the default cancellation order for Bryce Reed.
We have a motion and a second. All those in favor say aye. Aye. Any opposed, same sign. Motion passes.
The next case is an agreed waiver, and these are cases where a petition was sent to the respondent with a waiver attached, and the respondent ultimately signed the waiver. This means the respondent agreed to the executive director's recommended disciplinary action contingent upon the commission issuing a corresponding agreed order. In this case is for Brandy R. Cage, who was convicted or placed on community supervision for remaining after being forbidden, which is closely equivalent to a Class B misdemeanor in Texas. And this occurred prior to licensure. The respondent assigned the agreed waiver, conditionally accepting the cancellation, and the executive director recommends acceptance of respondent's agreed cancellation for your consideration.
I'll make a motion that we move and accept the cancellation waiver for Brandy Cage.
Second.
We have a motion and a second. All those in favor say aye.
Aye.
Aye. Any opposed, same sign. Motion passes.
The next two cases are agreed administrative penalty waivers, and these are cases where an administrative penalty was assessed in a notice sent to the agency with a waiver attached, and the chief administrator or designee ultimately signed that waiver. This means that the agency agreed to the executive director's recommended administrative penalty contingent upon the commission issuing a corresponding agreed order. First, we have Breckenridge Police Department, who appointed an individual that did not meet the minimum standards for licensing or appointment due to prior criminal history. In addition, the investigation determined an improper background investigation was conducted for this appointment, and respondent signed that agreed waiver, accepting to pay the $500 administrative penalty, and we recommend acceptance of respondent's agreed administrative penalty in the amount of $500 for your consideration.
I'll make a motion that we move and accept the agreed upon $500 penalty for Breckenridge Police Department.
Second.
We have a motion and a second. All those in favor say aye. Aye. Any opposed, same sign. Motion passes.
Next, we have the Galveston Police Department, who appointed an individual that did not meet the minimum standards for licensing or appointment due to prior criminal history. And again, in addition, the investigation determined an improper background investigation was conducted for this appointment. The department signed the agreed waiver, accepting to pay the $1,000 administrative penalty, and we recommend acceptance of the respondent's agreed administrative penalty in the amount of $1,000 for your consideration.
I'll make a motion that we move and accept the agreed upon $1,000 penalty for Galveston Police Department.
Second.
We have a motion and a second. All those in favor say aye. Aye. Any opposed, same sign. Motion passes.
Next, we have our agreed orders, and these are cases where a petition was sent to the respondent, and the respondent answered the petition by requesting a hearing at SOA, the State Office of Administrative Hearings. Prior to the hearing, a modified term of suspension was negotiated, and the modified terms were formally offered to the respondent in an agreed order. The respondent signed an agreed waiver conditionally accepting the modified terms contingent on the commission's issuance of a corresponding agreed order. First, we have James P. Fullen, who submitted personal history statements to the Galveston County Constable's Office Precinct 2 and the Texas City Police Department that were alleged to have omitted or failed to fully disclose information related to experience and employment history, financial history, arrest history, and civil court history. Respondent and the executive director negotiated a modified term of suspension, and respondent signed the agreed waiver, conditionally accepting a 6-month suspension, fully probated and backdated to begin on June 30th, 2024, and to end on December 31st, 2024. The executive director recommends acceptance of the agreed order, suspending respondent's license for 6 months, fully probated and backdated, for your consideration.
Commissioners, I did want to point out there is some public comment that was submitted to you for your review. It should be in your notebooks. I believe it's the last page of your packets, just for your information.
Madam Presiding Officer, I'm going to recuse myself from a vote on this, just the vote.
Okay, do we have any comments or questions, staff? Do we have a motion?
I'll make a motion that we move and accept the agreed order of suspension as recommended by the executive director for Sheriff James P. Fullen.
We have a motion, do we have a second?
And just to clarify, it's as laid out, which is a recommendation for 6 months, fully probated and backdated.
Correct.
Second.
We have a motion and a second. All those in favor say aye.
Aye.
Any opposed, same sign. Motion passes.
Madam Presiding Officer, may I say something?
Yes, sir.
So as you can see, we have a majority of folks from Galveston County in our audience today supporting the sheriff. This goes to the character, I think speaks to the character of the sheriff. Concerns that have been brought to me by some of the members who are here and others in the community about the ability for a complainant to turn TCOLE into a political pawn during elections. Something I think we as a commission and an agency need to look into to better understand. So a political investigation is not our goal, and only the standards that we uphold is what we're reaching for. So I appreciate the support that they have brought to us in this meeting and others in the past. And would just like us to try to figure out a way to be better in that regard where we can.
Any other comments or questions? Okay. Thank you, sir.
Can you hear me? There we go. Sorry. Our next case is Jose A. Hinojosa Jr., and he was convicted or placed on community supervision for driving while intoxicated, a Class B misdemeanor. The commission sought a 10-year suspension, and respondent requested a SOA hearing. The ALJ issued a PFD finding that respondent had been convicted or placed on community supervision for a Class B misdemeanor, and recommended that respondent's peace officer license be suspended for 180 days, followed by a probated suspension of 2.5 years. However, after the hearing, respondent and the executive director negotiated a modified term of suspension and conditions of probation. Respondent signed the agreed waiver, conditionally accepting a 3-year suspension, followed by a probated suspension of 7 years, as offered in the agreed order. And the executive director recommends acceptance of the agreed order, suspending respondent's license for 3 years, followed by a probated suspension of 7 years for your consideration.
Do we have any questions of staff? Any discussion? Okay, do we have a motion?
I make a motion that we move and accept the 3-year suspension probated with 7 years as conditions as recommended by the executive director for Jose Hinosa Jr.
Second.
Okay, we have a motion and a second. All those in favor?
I want to make sure, Commissioner Berry, let's restate it's a 3-year suspension followed by a 7-year probated suspension.
That was my intent, correct.
And Commissioner Burst, is your second still stand?
Yes.
Okay, we have a motion and a second. All those in favor say aye. Aye. Any opposed, same sign. Motion passes.
Next, we have Kevin D. Norton, who made, submitted, caused to be submitted, or filed a false or untruthful report of training to TCOLE. Respondent and the executive director negotiated a modified term of suspension, and respondent signed the agreed waiver, conditionally accepting a 30-day suspension. The executive director recommends acceptance of the agreed order suspending respondent's license for 30 days for your consideration.
Any questions or discussion? Do we have a motion?
Make a motion that we move and accept the agreed modified suspension of 30 days for Kevin Norton.
Second.
We have a motion and a second. All those in favor say aye. Aye. Any opposed, same sign. Motion passes.
Next, we have Chloe Orton, who made, submitted, caused to be submitted, or filed a false or untruthful report of training to TCOLE. Respondent and the executive director negotiated a modified term of suspension, and respondent signed the agreed waiver, conditionally accepting a 6-month suspension as offered in the agreed order. The executive director recommends acceptance of the agreed order, suspending respondent's license for 6 months for your consideration.
Do we have any questions or comments? Okay, do we have a motion?
I make a motion that we move and accept the modified agreed 6 months suspension of Chloe Orton.
Second.
We have a motion and a second. All those in favor say aye. Aye. Any opposed, same sign. Motion passes.
Next, we have Roscoe W. Parr III, who was convicted or placed on community supervision for driving while intoxicated, a Class B misdemeanor. Respondent appeared at an informal conference before agency staff, and after receiving mitigating evidence, the informal conference committee recommended a modified term of suspension and conditions of probation to the executive director. The executive director offered this to the respondent, and the respondent signed the agreed waiver, conditionally accepting a 7-year suspension, followed by a probated suspension of 3 years, and backdated to begin on March 31st, 2023. The executive director recommends acceptance of the agreed order suspending respondent's license for 7 years, backdated, followed by a probated suspension of 3 years
Any
for your
comment?
consideration.
Yeah, thank you. Any comments or questions? Okay, do we have a motion?
Do my best here. I make a motion that we move and accept the agreed upon 7-year suspension followed by a 3-year probated sentence backdated as recommended by the executive director.
Second.
We have a motion and a second. All those in favor say aye. 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 Any opposed, same sign. Motion passes.
Our next case is Walter B. Sharp III, who was convicted or placed on community supervision for driving while intoxicated, a Class B misdemeanor. Respondent appeared at an informal conference before agency staff, and after receiving mitigating evidence, the informal conference committee recommended a modified term of suspension and conditions of probation to the executive director, which was offered to respondent. Respondent signed the agreed waiver, conditionally accepting a 4-year suspension beginning on the date of respondent's discharge from community supervision, followed by a probated suspension of 6 years The executive director recommends acceptance of the agreed order suspending respondent's license for 4 years, followed by a probated suspension of 6 years for your consideration.
Any questions or comments? Do we have a motion?
Make a motion that we move and accept the executive director's agreed upon 4-year suspension with the 6 years probated with the terms that were just described. When was this to begin? At the date of?
Respondent's discharge from community supervision.
Yeah.
And the recommendations for 4 years, followed by a probated sentence of 6 years. And that is for Walter B. Sharp.
I second that.
So you got a motion and a second.
We have a motion and a second. All those in favor say aye.
Aye.
Aye. Any opposed, same sign. Motion passes.
Our next case is Cody B. Shook. Respondent acted as an instructor for courses without a valid instructor proficiency certificate or written designation as a subject matter expert. He also, as an instructor, failed to create and provide to the training coordinator the required course documentation for the training file. And finally, he made submitted cause to be submitted or filed reports of training for courses that did not have the required course documentation on file and readily accessible to the commission. Respondent and the executive director negotiated a modified term of suspension, and respondent signed the agreed waiver, conditionally accepting a 6-month suspension, fully probated and backdated to begin on June 30th, 2024, and to end on December 31st, 2024, as offered in the agreed order. Sheriff Cody B. Shook. That's correct. And the executive director recommends acceptance of the agreed order suspending respondent's license for 6 months, fully probated and backdated for your consideration.
Do we have any comments or questions?
I have a question. So he was submitting training records and course curriculum without being a licensed instructor. Is that my understanding?
If you're acting as an instructor, you either have to have the certificate, instructor proficiency certificate, or you have to be designated as a subject matter expert in writing. And he didn't have either of those for certain courses where he acted as the instructor.
Okay,
Does that answer your question?
it does, yes.
Thank you.
Do we have a motion?
I'll make a motion that we move and accept the agreed upon modification of suspension, being 6 months suspended and probated back.
Fully probated and backdated.
Fully probated and backdated
And that's for Sheriff Cody.
for Sheriff Cody Shook.
Second.
We have a motion and a second. All those in favor say aye. Aye. Any opposed, same sign. Motion passes.
Our last agreed order is for Jordan Stevens, who was convicted or placed on community supervision for driving while intoxicated, a Class B misdemeanor. Respondent appeared at an informal conference before agency staff, and after receiving mitigating evidence, the informal conference committee recommended a modified term of suspension and conditions of probation to the executive director, which were offered to respondent. Respondent signed the agreed waiver, conditionally accepting a 3-year suspension, followed by a probated suspension of 7 years, as offered in the agreed order, and the executive director recommends acceptance of the agreed order, suspending respondent's license for 3 years, followed by a probated suspension of 7 years for your consideration.
Do we have any questions or comments? Do we have a motion?
I make a motion that we move and accept the 3-year suspension followed by a probated sentence of 7 years for Jordan Stevens.
Second.
Okay, we have a motion and a second. All those in favor say aye. Aye. Any opposed, same sign. Motion passes.
Okay, the next two are default dismissal orders. First, we have Juan Palafox Jr. He was convicted or placed on community supervision for assault causes bodily injury family member, a Class A misdemeanor offense involving family violence, and the executive director sought revocation. Respondent requested a SOA hearing, but respondent did not appear at the scheduled hearing. SOA issued a default dismissal order remanding the case to TCOLE for informal disposition on a default basis, and the executive director recommends acceptance, the revocation of respondent's license as requested in the original petition for your consideration.
Do we have any comments or questions? Do we have a motion?
Make a motion that we move and accept the revocation of one Public Fox Junior's license.
Second.
We have a motion and a second. All those in favor say aye.
Aye.
Aye. Any opposed? Same sign. Motion passes.
Next, we have Rafael A. Rodriguez. Respondent was convicted or placed on community supervision for assault causes bodily injury, a Class A misdemeanor, and the executive director sought cancellation. Respondent requested a SOA hearing, but respondent did not appear at the scheduled hearing, and SOA issued a default dismissal order remanding the case to TCOLE for informal disposition on a default basis. The executive director recommends the cancellation of respondent's license as requested in the original cancellation notice for your consideration.
Any questions or comments? Okay, do we have a motion?
Make a motion that we move and accept the cancellation of the TCOLE license for Rafael Rodriguez.
Second.
We have a motion and a second. All those in favor say aye. Aye. Any opposed? Same sign. Motion passes. For the audience, whether you're here in person or joining us online, let me just go over a little bit about rules of engagement here. For TCOLE staff, you will have 5 minutes to present your side. If the respondent or their counsel is present, they will have 5 minutes to respond. TCOLE will have a second 3 minutes for any rebuttal. The respondent does not have an automatic rebuttal time. You may ask for one, and if granted, you will have 3 minutes. And if there's any additional public comments, those will be limited to 3 minutes also. So any questions about that? About the time?
Madam Chair, if I may, procedurally, I believe we have a timer somewhere for this. There it is. Fantastic. Well, that's, I'm sure it's, you can see it, Aaron, and whoever respondents or their counsel can see it. Just wanted to make sure everybody can see it. There it is. Thank you.
Thank you. I've been notified that the timer will beep at 20 seconds to warn you, and then will beep again at 0. Thank you, I appreciate that.
Are you ready, sir?
Yes, ma'am.
Okay.
This is the proposal for decision for Jeffrey Seif. Respondent acted as a training coordinator for the Dallas College Law Enforcement Academy, and he failed to enforce all admission, attendance, retention, and other standards set by TCOLE and approved by the Academy's advisory board when respondent included students on the reports of training that should have been dismissed from the basic peace officer course according to the standards contained in the Academy's cadet manual. Respondent requested a hearing at the State Office of Administrative Hearings, and the Administrative Law Judge at SOA issued a proposal for decision finding that respondent submitted a report of training for Academy Class 111 that failed to ensure compliance with TCOLE rules and failed to enforce all admission, attendance, retention, and other standards set by TCOLE and approved by their advisory board. But the ALJ did not find that respondent submitted false or untruthful report of training and recommended that respondent receive a reprimand. The ALJ determined that TCOLE statutes and rules did not prohibit the Academy's advisory board from granting respondent discretion to waive requirements in the cadet manual on a case-by-case basis and did not require that grant of discretion to be included in the cadet manual. The executive director recommends modifying the PFD by removing conclusion of law number 19, but otherwise accepting the findings of fact and conclusions of law on the PFD and that respondent receive a reprimand. I'm available for any questions.
For the commissioners, any questions for Mr. Heath?
I have one question specifically about the removal of Rule Law 19. What is that rule of law? The refresh. I read through this 3 weeks ago, so what was that?
Conclusion of law number 19?
Yes, sorry.
So this conclusion of law number 19 is referring to the meaning of false or untruthful and TCOLE's rules regarding the submission of a false or untruthful report to TCOLE. And we disagree with the interpretation. The case that they cited, Stacks, mentioned it defined untruthful in our F5 designations back when we had designations. So a prior case. And the case states that the plain meaning of untruthful extends to both outright falsehoods as well as misleading or deceptive representations. And that the ALJs determined false. First, they said that they had to be two distinct terms. And then they used false as one of these. Some of the definition of untruthfulness in this case includes what they determined false to mean. And our interpretation is that untruthfulness, there's intent behind it, whereas false, it's inaccurate, incorrect.
Thank you.
Okay, so this was quite the read. I don't think I've read a PFD that is quite so colorful, for lack of a better term. I'm just kind of curious. I did not go back and look at, have we seen these ALJs previously? I also found it interesting that there were 2 ALJs that took this. So the whole thing was just kind of a little odd, a little jarring. And like I said, the language was very strong. I had to check, like, am I reading a pleading from the other side, or am I reading what the ALJs have said? So can you just elucidate kind of your thoughts and what's going on? Tell us a little bit more about this one.
In my experience, I've seen, starting with the ALJs, I've seen multiple ALJs handle a case before, but those are usually multi-day, up to a week-long hearings that cover a lot of technical, complex issues. I believe in this case, and now I should say that this was handled by the Attorney General's office, so I wasn't the attorney representing us, and I wasn't at the hearing. My understanding is that one of the ALJs was training, and so she was there to learn from the other ALJ.
I have a question, and I'm not sure if this was argued or not, but why was American Heritage Dictionary used for the definition of false or untruthful rather than like a Black's Law Dictionary, which says it as not true, essentially?
For our definition.
I don't know why they used that particular dictionary and not Black's.
Just as a comment for any ALJs listening, I would go Black's, Webster's Second, Webster's Third, New American or American Heritage for persuasiveness for me personally.
I agree with that, but I would add with our definitions. Maybe make a mention that you look at our own definitions.
Right.
Okay, Aaron, I'm still waiting for a little bit more information on like the spicy level of this. or John?
Be glad to jump in on this, Commissioner Burris. I think we've all certainly, those with some experience beyond recent experience, I can only speak to, say, 2007 with respect to reading proposals for decisions that are presented to you all. I will say this is unique, both, it's obviously lengthy, one might even be uncharitable and say a turgid reading or writing of this proposal for decision. I do think the tone and tenor is probably more, I think Commissioner Burris touched on this earlier, I think it's more adversarial. I think it's more advocacy versus fact-finding or applying the law or our rules to it. I do think it is a new situation that we've encountered, and I think we've talked a little bit about this in recent months, but it was in shorter spurts and certainly not to the degree which you have before you today. That's why we got this out to you a little extra early so you could begin digesting this thing. I think, and I certainly don't want to speak for the executive director, with respect to what the message is versus how it got to you, message versus messenger situation. I think you see the ultimate recommendation by the executive director for a reprimand, and based on what the ALJ said, and certainly with respect to this type of how are we approaching the regulation of advisory committees? How are we approaching academies? How are we approaching things of this nature? While the method for which this message was delivered, certainly it's probably not as tactful or as artful as we all wish. And again, I don't want to speak for the executive director, but I can certainly speak to the conversations that we had with respect to the subject matter and how TCOLE moving forward with the resources which the legislature has given us over the last two sessions, which can address academies, advisory committees, things of that nature. We have an opportunity which we have never had before to address some of at least the general subject matter for which this proposal for decision is speaking of. Again, separating the message from the messenger, and ultimately that's how we ended up with accepting or recommending the acceptance of the reprimand. I hope that answered some of your questions.
It does. I guess I just, I just have continued commentary on it because it was very jarring to read something that's addressed to us in this tenor. That's something, my last decade plus of practice has been exclusively in federal court, and this is not how one is treated. And so I don't know, I needed to make a comment about it. I would expect to be kind of chastised the way we seem to be in these writings if maybe we were hiding the ball. We weren't being truthful. We weren't putting everything out there. But we have zero history, to my knowledge, of ever hiding the ball, of ever not being professional, of ever. We aim to put everything out there and we argue our position. And I guess I just wanted to put out there my comments on this, and I'm concerned that we already talked about this maybe one or two meetings ago, kind of how the tenor is changed, and that may be speaking to national shifts, statewide shifts. I don't know, but it has not gone unnoticed, and I don't I don't know how much longer and how much further this kind of language goes before I feel like it's necessary to say something. So I'm just putting it out there, and I'm not talking about you all doing that. That is not your job to do, but myself as a public member, I have every right to speak my opinion. That's why I was placed on the commission. And so I get to say these things without, as long as I don't embarrass the governor. It's what I've been told each time I've been appointed, and I would not aim to embarrass the governor, but to make known kind of what's going on. I would ask that usually in practice, the attorneys, you'll know, like sometimes you keep a list of lawyers, of judges, kind of the way they tend to rule, different things like that. And this makes me think of, kind of tracking maybe what we're seeing for trends and things like that going forward. So I would encourage that.
We appreciate you all noticing. We appreciate your comments, and it has not escaped our attention either. Thank you.
I also have some comments, but I'm going to save mine for a little later on if I may.
Okay. Do we have anyone here that would like to respond? And if so, if you'll come up to the front, please state your name for the record and who you are and your relationship to the case, and then you will have 5 minutes. And please know it's not 5 minutes per person, it's 5 minutes total to respond.
I understand. Thank you, ma'am. My name is Jim Inside. And I am representing myself here. When I received a disciplinary notice from TCOLE, well, when I first was informed that TCOLE was displeased by my performance, I immediately tendered a resignation from the academy, Dallas College, and I likewise tendered my resignation. I held appointments with DeSoto Police in Dallas County and Ovilla Police in Ellis County as a reserve. Upon receiving notice then from TCOLE that TCOLE was looking to vacate my license, suspend it for 2 months, and take away my basic training instructor certificate, I opted to go to SOA for that at my own expense. And I would like just to read what SOA said at the end. It was rather lengthy. They said, outside of the staff's, and I'm looking at page 83, entirely unproven theories in this proceeding, there's not any hint or any allegation that Dr. Seif has ever violated any law or TCOLE rule. This TCOLE licensed peace officer and instructor has been anything other than exemplary in his leadership of the academy or other professional or personal pursuits. And then they quote Malcolm Jackson, who was the TCOLE ace, who I had worked under, who testified on my behalf, saying, I never did anything that he didn't recommend doing. TCOLE argued that I violated my advisory board policies. The chair of our advisory committee came and testified and said, no, that he never violated anything, and a lawyer on the advisory board similarly submitted a letter to that effect. I can't speak to the energies. I was pleased to see this because it seemed a robust response. Sometimes when people investigate, we just don't always get it right. And there was exculpatory information I don't think ever came to the fore. In any case, I'm not altogether clear why, but on my own behalf, the reason why I am begging the commissioners to vacate this entirely isn't because I'm anxious to reinstate as a police academy director. I have other brands in the fire. I'm on the cusp, just a half-inch away from receiving a PhD at Cambridge University in criminology, and my research is in training. I have a master's degree from Cambridge University in applied criminology and police management with an emphasis in training. I am interested in training. My research, it's broadly looking at the Bureau of Justice Statistics training trends in North America, but in Texas specifically, I've been into TCOLE for all the records to look at ethics and what have you. And personally, I'm pleased by what I see. The reason why I am asking the the commissioners, I'm begging you to please just vacate this entirely. And asking you to do that, I'm asking you to go with what SOA had recommended. They go on to say, quoting Malcolm Jackson, who was the TCOLE, the fellow that I'd worked under. He said, and I quote, "Seif was a relief for TCOLE and earned praise as one of the premier individuals who was focused on trying to achieve TCOLE compliance and making the academy one of the outstanding academies in the state." And then they go on to say the staff didn't dispute this. And they finish here. They don't finish them. I don't want to just read, 90 pages worth of work. They even note that when TCOLE produced their most recent manual for instructors, they cite my work, as having contributed to it. They said here that Seif's work has become one of the models of source materials for TCOLE's instructor handbook, as noted in the publication's acknowledgement. I'm asking TCOLE, thank you very much for your time.
Thank you, sir. Mr. Heath, will you be providing a response?
Yes, very briefly. First, Malcolm Jackson is no longer with the agency, and the instructor handbook has been withdrawn and is not available anymore. Also, recently, the Dallas College Law Enforcement Academy was placed at risk, the correct term? They were placed at risk, which kind of negates the idea that they were the model for the state of Texas as a law enforcement academy. And that's all I really have for you. If you have any further questions.
I have a question for you or anyone on the staff that could answer. And I really wish our colleague, Commissioner Atkins, was here with us today, but she is not. So running an academy is a full-time job. That is my opinion. And sir, I heard what you said, and I mean that very impressive accomplishments, but I can't help think that took you away maybe from primary functions. So in looking at the academy, did you find that the management of it was comparable or not to the way others were managed? Does that make sense?
At Cambridge University, I went through their police executive program. It's all, well, mostly police executives that superintending, the agencies in Europe are much bigger, 1,000, 2,000 under their command. The way it's set up is you'll go there for 2 weeks, 3 times a year, and you do the reading. It's not like I'm out of town.
Yes, sir, I'm familiar with the program.
Okay, sorry. what SOA said relative to the reprimand, that before I left for Europe, I instructed one of my lieutenants, I had a lieutenant at each of 3 locations, to remove someone from the docket. And then I went to Europe, as is noted in the SOA hearing. When I was in Europe, it slipped through the crack, and she didn't vacate that person. So SOA said, I'm ultimately responsible for it, and I accept responsibility for it, but it's not false and misleading on my part. Administrators, I only hope that the things that I do right in life outperform the things that I do wrong. I don't think the academy was just sliding off the rails because I'm just negligent in a way. And one thing else, if I may respond to the academy being put on probation, as was noted, you don't want.
We're not going to go there because
Okay.
that's not a part of this. And if I could get a response from staff also, I'd appreciate it.
Chief, could you rephrase your question?
You have the opportunity to see academies across the state of Texas. You're responsible for assisting them, for overseeing them, disciplining them. Can you provide some kind of context for the management of this academy?
In this particular case, it appears the advisory board gave the training coordinator far more discretion than we anticipate them doing. We look at the student course manual that the advisory board by rule is required to vote in as the contract between the training provider and the student. And it is a declaration. That's what we look at when we come to look at an academy. And so for them to say, okay, at whim, or some level of discretion, you don't have to follow this contract that we made between training provider and student and that the advisory board passed. And I believe in the opinion it pointed out that level of discretion wasn't outlined in the manual. You didn't put the students on notice. And so that in the totality is one of the things that led to Dallas College being put at risk. Now, I do want to say in the record, they have remedied that and they are no longer there, just so that we're clear of their standing as we talk about them in an open forum. So Dallas College is no longer at risk. They have worked through all the challenges. I just want to make sure that for the public that's understood.
Colin, can I add to that? And that you drafted a letter in the at-risk that outlined specific objectives and goals for them to meet. And I think those could be described as management functions. For example, they were operating several campuses with very small student groups. They were breaking up the lessons in different ways and doing different tests, recommended consolidating that, about updating the manual, applying it equitably and consistently. And so a lot of those things had deadlines that they had to meet. And again, that could be interpreted as being management expectations that you needed to get to in order to reach the minimum standard we expected to continue operating in an academy.
I have a few questions as well, if I may. We just took action on Sheriff Cook a little bit ago for basically operating as an instructor when he wasn't licensed to do so, correct? And I'm getting to a point with this. Is that correct?
Shook?
Correct. Mm-hmm.
Yes, that's, well,
Correct. We just took action because
that's a part of it.
Part of it, right? I'm on page 47 of this document from the ALL judge, where we talk about a person identified as student 105-6 and their failed attempt at skills in driving. And then a person was brought in secretly that was not the subject matter expert for driving skills, right, to go and pass the student. Is there a difference between the person that was used to pass this that is not the instructor or the qualified subject matter expert, and then what we just took on Sheriff Shook? Is there a difference between the two, or were they both operating not as approved instructors for that course content?
I believe the ALJs addressed that issue in their PFD. He does have an instructor certificate, so there's nothing saying he's allowed to do it. Whether he has the required expertise or not was what was in question.
Right. And I think all of us that have driven these cars very fastly at a high rate of speed and what's at stake, it's very important that competent people that are the subject matter experts, at least in these skill sets, are the ones doing these evaluations. Is that a fair assessment, a fair statement? I guess I'm putting an unfair statement out there. It's my belief that maybe that's something we need to look into then. Yeah, it was brought into this. It was in my questions is, skills versus academic tests. And that seemed to be a big thing at stake here with the judge's opinion is that, well, we don't seem to have a standard to fire someone because they fail a skills versus a test. And I don't know, I need to do a deeper dive into that, but that was something that stood out to me is, I'm sorry, driving these cars fast, we have a duty to drive with due regard of others. It's in statute and how we operate these vehicles and make sure that we are meeting that skill set standard. And so I just want to put it out there that maybe might be worth us looking a little bit more into about that portion of the LJ's concern on that. And I do have some more deeper comments about this, but I want to wait till after our decisions because it ties directly into these academy boards because I've got a plethora of concerns about how the academy board did what they did. And I've got a lot of concerns with that.
Sir, when you say you want to talk about later, do you mean before we make a decision on this? Or?
No, after our decision, I would like to make a comment about the academy boards, if that's the more appropriate time, or I can say my comments.
I'm happy to hear you
Yeah.
voice your concerns right now.
Yeah, so these are my concerns is, first I want to thank Dr. Seif because you did bring many of the challenges and issues that are facing academy boards to our attention. And so I want to thank you for that. I also want to thank our enforcement staff for following their compass that have been given to ensure that our training academies and those responsible to be the sound gatekeepers of those academies are doing as they should. With the recent ALJ interpretation of this case, I have cause to be concerned that any Academy Advisory Board now has the ability to circumvent the duty of TCOLE to ensure that the BPOC, along with the standards of training for every Texas peace officer, jailer, and telecommunicator we are entrusted by the legislative body of Texas, is met. The LJ says in bold, no statute or TCOLE rule prohibited the Academy Advisory Board's delegation of discretion to Dr. Seif, nor required it to be memorialized in the cadet manual. In fact, the LJs do not understand staff to dispute that fact. The Academy Advisory Board in this case seemed to be empowered by the ALJ's decision that they can waive the standards set by TCOLE and worse, nullify them at their discretion. Sadly, the misinterpretations of why Academy Advisory Boards were established does not seem to be contained to this one board. There are other Academy Advisory Boards that are currently taking action to reimagine public safety, to implement a variety of changes to include implementation of DEI initiatives in the training academies, to rethink training approaches and curriculum content among sworn instructors. Some samples of reimagined training curriculum are being taught by third-party training contractors that is currently teaching a groundwater analysis course that in summary simply instructs law enforcement officers to use a racial equity lens in their sworn duties, while also instructing Texas peace officers that they are part of a systemic racist institution. Furthermore, the same advisory board has now created a mandatory pre-academy whereby many sworn instructors have been refused entry into the pre-academy classes being taught by non-TCOLE certified instructors. This pre-academy has also been deemed a mandatory requirement for this agency's BPOC curriculum. My concern is that with this recent ALJ ruling, The ruling will allow the continued erosion and standards set forth by this commission, by Academy Advisory Boards. The allowance for abuses and misunderstandings of TCOLE rules and standards must be addressed. In order to assure we are not absconding our sworn duties as commissioners of TCOLE and to address the points made by the ALJ in this case, I do respectfully move that we discuss a proposed rule change, TCOLE Rule 215.7, Training Provider Advisory Boards at our next meeting in February 2026. And knowing what's going on in some other academies around this state and seeing, I don't know how they came to the conclusion that the LJs did. I've read this. I get Dr. Seif wanting to be focused on training when he was just up here talking about training. Training is very important, but so are the standards that go with that training. The same requirements that I had to go do to earn my badge, to earn my commission, the same as the other sworn commissioners up here, same as the deputies that were just sitting back there in that room a little while ago, same as the ones that were out here in the honor guard, and the same ones that are out there all across this great state, had to meet a standard, not just get trained, they had to meet a standard. And to circumvent that standard, I've watched many good people when I was in the cadet class fail to meet the 80% grade at our academy. These are people that I was like, man, these are gonna be good cops. It was hard to watch them get cut, but they got cut because they didn't meet the standard. I think the standard portion is what's really important here. Training is great. We can train all day long. We need training. We need great training. But we also need to make sure that the standard to wear this badge in this profession, especially in this time, this day and age of policing, when we're under such scrutiny across the nation, is vitally important because so much is at stake. And so I don't mean to get passionate about this, but when I read this and to watch the potential erosion by other groups to use Academy Advisory Boards as a mechanism to undermine and erode that standard that is being set before by us is of great concern to me.
I want to make sure that we're not muddying the water here. We are here to discuss and take action on this particular case. I hear what you're saying.
Which is why I wanted to wait till after we made our decision. But
And we can certainly put that on the agenda for the February meeting. My response to you is yes, I think that there are some potentially some rules that could be tightened up to address your concerns, but I also want to be careful that we don't take a potentially statewide or systemic problem and apply it here, because this is really about the facts of this case and what happened in this situation. And I'm going to humbly disagree a little bit because I hear what you're saying and your concerns, but I also think that there are a lot of rules and standards that are in place. And for me, it's very clear. It's much more clear. It may not be clear to the advisory boards. And I think what I hear you saying is that there might need to be some additional oversight of the advisory boards or something in place to, provide some boundaries or oversight with that group. But I don't think it changes the fact that, again, in my humble opinion, related to this case and situation, everything was pretty, we already have rules, we already have standards, and they're clear, and our decision really is, were they met or not? Was there a violation of those or not? So.
And I don't disagree. That's why I was planning on saving this for after our decision, because I do think the two are separate, but there is an underlying issue at the root cause that is greater than this one case. So I do want to make sure that is very clear that,
Yes,
my
and
statement on this was.
it will be on the agenda in February.
Yes, and I think that's a better time for us to discuss that, because I do think looking at this in Dr. Seif's case while he's here, I saw some concerns, but I did see some points that ALJ did brought out that showed us an area where we could do some improvement upon. But I I look at the standards that are set by TCOLE here and seeing some variation of that in this case with regards to grades and driving skills tests that caused me some concern as well.
Understood, and I don't disagree with you. Commissioner Burris.
I feel like the executive director is about to say something.
So I made the recommendation that we accept the PFD with the, exactly. And so that you understand why I make that recommendation, because when we first received this PFD, my first inclination was to have general counsel and his staff do exceptions, because it was my belief that that the academy was way off track and allowed students who did not pass, they allowed them to pass, and that was unacceptable to me. However, after reading through the full PFD and sitting down with our general counsel and go over it, what I appreciate, much like what you'd said, Commissioner Berry, I appreciate the ALJ for pointing out where we can improve our some of our rules, perhaps, and some of the way that we do oversight in the academies. TCOLE has lacked capacity historically to have good oversight in the academies. Thank you to the legislature and the governor's office for now. We are building that capacity as Deputy Chief Grissom and Captain Antu are building out that team, and we are reviewing the contracts that we have with the academies to prevent this from happening again, because I do believe it was a failure. But again, I think that after reading through the entire PFD, while I think it certainly could have been more professionally done to point out, I don't mind saying that. I think it devolved into an unprofessional way of simply saying, hey, there were some parts in here where your rules don't necessarily back up what you want to do. And so it's an opportunity for us to improve and have the oversight that we need to. And so that's why, after talking over it with general counsel, I think the best path forward for us is to, and that was my recommendation, the changes that Aaron talked about, is to accept it as it is and do the reprimand so that we can move down the road and ensure, with the new team we're building, new funding, new people, prevent this from happening again, where people that really didn't pass were allowed to pass.
Well, I guess to the presiding officer's point, to bring it back, I would just say, I think false means objectively untrue. Untrue means intent to deceive, whether ultimately false or not. That gives effect to both terms and doesn't make any surplusage. They could overlap in some instances, but not necessarily always. I think the buck has to stop somewhere. Without a reprimand, there's perverse incentives of less oversight to say, well, I didn't know it was a subordinate, creates bad systems, and I think a reprimand here is fine given the facts of the case. And excluding the conclusion of law number 19 based on the definitions.
I literally wrote in my notes, and Sheriff Griffiths can see, I wrote, the buck stops with you. I'm sure, Mr. Seif, you were mortified, given your background and history, to be in this position. And I, as an overachiever, I can totally appreciate that. It's wounding to oneself. However, and not necessarily through fault of your own, in a sense that the advisory board changing the rules in the middle of the game made things better for some of these students and worse for some of them at the same time. And that's unacceptable, and it is written that is not to be done in the middle of a class. It makes perfect sense. That's how our laws work. You have to have notice of expectations. It's what everyone has in a job description. If you've ever gotten one, you need to know what the expectations are, what the standards are, so that you can do that and meet those. And if you don't, you understand why you did not reach those standards. I agree, standards are very important. That's what we're here to do. And not only I mean, at the base level, we're here to set minimum standards. We can, of course, always aspire for more and to do better. And just to circle back to, at the end of the day, this opinion and everything that came out with the decision, there's some area for improvement, and we'll do that. We want to always be very clear about what our expectations are with our academies and with standards. On the larger issue, if I'm still here in February, I may have some words with Commissioner Barry, because I heard like DEI flying about, and I'm probably going to have a different opinion from what it sounds like on that does not lower standards by any means. But given where we are here today, I think, like I said, advisory board, move the ball, the buck stops with Mr. Seif, and reprimand at the end of the day, going through all the different iterations and till we get to this, I think that is appropriate. Oh, and one final thing to point out, this was in Deputy Chief Vineyard's portion of the PFD is, a warning letter has gone out. And if you've been working with the commission and with your local agent, you should be very aware and have a great relationship so that you don't get to where we are here today. We give lots of warning. We're about educating, continuing to educate, rehabilitating. We want agencies and colleges to succeed. And so we are here for a reason. I'm happy to hear that Dallas College is back on the right track. That's the point. That's what we want. It's what we want to see. But I think where the agency is asking us to land is a fair place.
All right, Mr. Seif, I'm going to ask you a couple of questions if you want to come back up and give you opportunity to speak a little bit. I appreciate you coming. I met you at the door when you walked in, of course. You're fine. When you were up here speaking a moment ago, you were asking us to just vacate this whole thing. And then later on, you said, yeah, it's my responsibility. I ultimately let these people do this when I left. They just didn't do it. It's my thing. So as a commission, we're evaluating what we're going to do at this point. What, after reading this hundreds and hundreds of pages that we have to read about your case, at what point do you say, commission, vacate this for me, but it's my fault? I mean, I'm trying to understand where you're coming from to have us ask that question, even though you're accepting responsibility for an issue.
Sure. It's a reasonable question. And when vacate, maybe there's a better word that I could use. It seems that what my head is on the block for is a disciplinary notice, a slap. And what I'm looking is for the removal of that. Relative to the sum of all these things, police officers use discretion all the time. And there isn't a chief, there isn't of an agency, there isn't an officer on the street that doesn't use officer discretion. In the 7 cases that were brought forth, 6 of them were found to be entirely reasonable for the discretion that I used. For example, it is true that there were scores under 75 for 4 that should have resulted in vacating, but then the instructor for the course came along and said, I gave the wrong review, the wrong material, and I opted to not vacate the score. I left it there, but I didn't want to penalize the cadets for a mistake that the instructor made. There was attendance rules, yes, but the attendance snafu was, remember, we're COVID and coming out of COVID, that arrangements were made to present the class digitally, and we're right at the end. And what happened is the instructor didn't do it, with the net result then that the cadet could not sign in for it, with the net result they went over. And there again, I didn't want to penalize. Relative to the driving course, it wasn't the EVOC course. It wasn't the emergency vehicle operation course. It was NEVO, non-emergency vehicle. What it amounted to was someone failed to go in reverse. The instructor, I have 20 complaints in my file that he has problems with picking on foreigners. And this was a Pakistani student who was riled. So when I say vacate, I think relative to the specifics, I think there indeed are mitigating circumstances. Relative to the one person that did go through, I did say that they should be removed, and they weren't. I suppose what I'm asking the commission to do is to be gracious. Whatever the systemic issues might be with police training and advisory boards, I worked under the advisory board, and it was staffed by competent people. The head of the board was a professor in police science. She had a career in it, and there were police chiefs on the board. It wasn't just a bunch of, people. So I think that maybe there are systemic issues. There's a way to tighten it up, but relative to this case, I suppose I'm just throwing myself to the commissioners and saying, please, just, I just would rather not have my reputation tarnished by this. But maybe tarnish is overstated. Disciplinary letter is not the end of the world. I realize.
Well, so the question I asked was, why should we do that? You went and restated what you have already stated that we've already read about these individual cases, which SOA has said, all right, so we're not going to suspend you. We're going to let a reprimand. So what you've just explained to us is what got your action reduced from a suspension to a letter of reprimand.
Okay.
So your request for us to just vacate this altogether seems wildly out there, in my opinion.
Well, let me succinctly say, in the interest of justice, that's kind of like the line that, in the interest of justice, I would ask the commissioners to please just vacate this.
Well, I think the mercy is the lack of the suspension, so you're not going to be suspended. However, you say the buck stops here. You say it's your ultimate responsibility. These things happen. The advisory board specific, ignoring what was said about other academies, your specific advisory board made decisions to remove the minimum standard that TCOLE has set.
No, TCOLE does not set a standard for the policies here. The advisory board sets a standard. No,
minimum, please don't talk over me. The minimum standards at TCOLE's job is minimum standards. Right. We look for minimum compliance, voluntary compliance from our licensed community. That's what we do. We are really trying to balance compliance versus penalty. And when we go down that road, we can't have the scale that we're trying to manage have a thumb put on it from an advisory board saying, oh, your standards that you're trying to apply to our case should not be applied. Well, so my question specifically to you is about why we should just, as you said, vacate. So before you talk over me again, looking at the SOA and the recommendation of what Director Stevens has already stated after speaking with council, rather than go and put a bunch of exceptions forward to the ALJ to say, hey, we want all this stuff, you have not put forward a reason at any point today that would say, hey, we completely missed that. What you've done is you've restated this very lengthy document in a much smaller summary. So I'll allow you to have your succinct point, but that'll be probably it for this.
Okay.
Okay, and before you respond to him, I'm going to add a little bit to it. as the academy director, at the end of the day, you are ultimately responsible for the cadets, for the instructors, the people that you hire, what they do in the classroom, the content that they provide to the students, and I'm not hearing responsibility for that. And that troubles me, and I think feeds into what Commissioner West's point is that that's your responsibility. And even when it comes to the advisory boards, I have had academy advisory boards as the training commander. I have also sat on academy advisory boards. I don't know a one that didn't look to the director as a source of expertise and wanted that guidance from them. So I think at the end of the day, they're your standards and you need to own them. So I'm not hearing that.
Okay. Apologies for stepping over. Sometimes it's best to not have yourself, it's best for someone else to represent you because you're emotional. And so because I perhaps am not presenting myself as clearly as I otherwise might be, because this is the end of an ordeal for a number of years. Per my understanding, that the issues at hand are not related to violating any TCOLE rule whatsoever. The academy sets the policy for 3 strikes and you're out under 75. It's not a TCOLE rule. The academy sets the attendance policy. TCOLE doesn't. And having an instructor come and assist them with the non-emergency vehicle driving in reverse. This detective, 25 years with Dallas PD, homicide detective, to be able to determine if someone can drive in reverse without hitting cones. That it doesn't violate a TCOLE rule. These are academy standards, and we're looking at unique circumstances, COVID and coming out of, and the academy was specific in working on a case-by-case basis. If they thought, in my judgment, I thought it was warranted. And I exercised my judgment, and I gave the break. And so I accept responsibility for it. Certainly, if the commission, I'll accept the judgment. Of course, I'm pleading my case. Mm-hmm. It doesn't mean I'm dismissive of you. It just means I'm pleading my case.
No, we appreciate it. And then I thank you for your time, and I'm not going to ask you to respond anymore. Just to make a statement. The presiding officer has pointed out the same thing that I was hinting at, was that you again are restating what's in this document. There is a question of a false report. I mean, if we just boil it down to one thing, we're looking at this case as you ran an academy, you had things take place that you were responsible for while you weren't even in the country. You're still responsible. And not once did it feel like in this document or from you that you understand that, hey, this is something I did. I need to be better. I need to find a way to make this happen better. You resigned from your appointment there, you resigned from your PD, and you're only fighting the loss of your instructor certificate and the suspension. So I'm going to agree with my colleagues here and say that I believe a letter of reprimand is warranted here. As you said, it's not the end of the world. It's a tarnish that you've got to work through. But at the end of the day, hopefully this makes you to be that better person as you're pursuing these additional degrees and things. We just need to be consistent when we apply these rules. We have a cancellation on our agenda that we've already gone through today. Someone who was not eligible to be licensed. We have academies that have passed cadets that were licensed and cancellations went out. We've had a number of those in the last 2 years. So we can't be inconsistent in that application of what we do as TCOLE and the minimum standards that we set.
I'm ready to make a motion.
Do we have anyone else that is signed up to speak on this matter? If you'll please come forward, state your name. Okay. Do we have any other comments or questions from the commissioners? Okay, do we have a motion?
I'll make a motion to accept the findings of fact and conclusions of law in the PFD, including the modification to the removal of conclusion of law number 19, and that the respondent, Jeffrey Seif, receive a reprimand.
Second.
We have a motion and a second. We are going to do a roll call vote. Count down.
Commissioner Kim Lamo,
Aye.
Commissioner Justin West,
Aye.
Commissioner Patricia Burris,
Aye.
Commissioner Michael Griffiths, Commissioner Justin Berry,
Aye.
Commissioner Connor Harvey. Motion passes.
Yeah. Mr. Seif, again, thank you for traveling from the North Texas area out here to East Texas. We very much appreciate your time. I think we all appreciate and respect the passion that you do have. I will make the statement that I think oftentimes when we are presented with these types of cases, it's a learning opportunity for everyone. And this certainly, I think, pointed out some ways that that in that position, you know, you had opportunities, maybe you do things differently. And I think on the TCOLE side of things, I think there's also an opportunity for us to, you know, to look at some of what we're doing and potentially make some changes. So as several of my colleagues stated, you know, we do appreciate the opportunity to do that. And by virtue of your case, you've given us that opportunity. So thank you very much. And again, thank you for your time and for traveling here today. We very much appreciate it.
Our next PFD case is for Miriam Z. Valero Acosta. A respondent was convicted or placed on community supervision for assault by contact, family violence, a Class C misdemeanor offense involving family violence. The executive director sought revocation and respondent requested a SOA hearing. After the hearing, the ALJ issued a PFD finding that respondent had been convicted or placed on community supervision for an offense involving family violence and recommended the revocation of respondent's telecommunicator license. And we recommend acceptance of the PFD and the revocation of respondent's license for your consideration. I'm available if you have any further questions.
Do we have anyone signed up to speak for this case? I am not seeing anyone come forward, so I will ask my colleagues, do you have any questions for Mr. Heath or staff or any comments? Okay. Do we have a motion?
I make a motion that we move and accept the revocation of TCOLE license for Ms. Valero Acosta.
Second.
Okay, we have a motion and a second. We will do a roll call vote, please.
Commissioner Kim Lamo,
Aye.
Commissioner Justin West,
Aye.
Commissioner Patricia Burris, Commissioner Michael Griffiths,
Aye.
Commissioner Justin Berry,
Aye.
and Commissioner Connor Harvey.
Aye.
Motion passes.
Thank you, ma'am.
The next PFD case we have is for Christopher M. Gessner. Respondent was convicted or placed on community supervision for assault by contact, a Class C misdemeanor offense involving family violence. The executive director sought revocation and respondent requested a SOA hearing. The ALJ at SOA issued a PFD finding that respondent had been convicted or placed on community supervision for an offense involving family violence and recommended the revocation of respondent's jailer and peace officer licenses. We recommend acceptance of the PFD and the revocation of respondent's licenses. I'm available for any questions.
Do we have anyone here to speak on this case? Again, I'm not seeing anyone come forward. Do we have any questions or comments from the commissioners? Okay, do we have a motion?
Make the motion that we move and accept the revocation for the jailer and peace officer licenses of Christopher Gessner.
We have a motion and a second. And although it might be easier just to do a vote, I want to be consistent.
Our next PFD case is for Rachel L. Mariano. A respondent was convicted or placed on community supervision for possession of marijuana less than 2 ounces in a drug-free zone, a Class A misdemeanor. Due to this offense occurring prior to licensure, the executive director sought cancellation and respondent requested a SOA hearing. The ALJ at SOA issued a PFD finding that respondent had been convicted or placed on community supervision for a Class A misdemeanor prior to licensure and recommended the revocation of respondent's peace officer license. The executive director filed exceptions to the PFD, requesting the change of a technical error to correct the license action as cancellation.
Again, not seeing anyone come forward. Colleagues, do you have any questions or comments? Do we have a motion?
Make a motion that we move and accept the cancellation of Rachel Mariano's TCOLE license.
We have a motion and a second.
Commissioner Kim Lamo,
Aye.
Commissioner Justin West,
Aye.
Commissioner Patricia Burris, Commissioner Michael Griffiths,
Aye.
Commissioner Justin Berry,
Aye.
Commissioner Connor Harvey. Motion passes.
And I believe we are going to go to Assistant General Counsel Mark Duncan for the remaining 3 cases, if that is correct, sir.
That is correct. It is 2 cases. We did settle the Hinojosa case, but and out of curiosity, is anybody here for Robert Beltran? Okay. This is a summary suspension case. Unlike the other PFDs you'll hear today, this case arises from indictment, not a final criminal disposition. Constable Beltran's peace officer license is already suspended under TCOLE's felony suspension rule for crimes that constitute immediate peril to the public health, safety, and welfare. He appealed that suspension. The ALJ found that our suspension is warranted and may continue until the disposition of his criminal case. Respondent was indicted for felony offenses of injury to a child, elderly or disabled individual with intentional bodily injury, and also for unlawful restraint of a child younger than 17 years of age. Because these felony offenses constitute peril to the public welfare, where he was able to maintain his license, staff recommends acceptance of the PFD and the continued suspension of his license until the disposition of his criminal case. Do you wish to respond?
Madam Chair, if I may, I have like for Mr. Duncan. Mark, could you tell us, is there anything with respect to Constable Beltran's office or his license, how that affects him holding the office, as this question comes up frequently both at the SOA hearings and both in the summary suspension context and with other constitutional elected officials, sheriffs and constables?
Yeah, so the big picture on this, not relevant to this case, is that we seek these suspensions and we're not arguing the facts. I mean, these are prior to criminal disposition. Does it fall under this rule? We can do a suspension. We don't want somebody who has our license to use that license to commit these kind of crimes. The license is suspended, but we don't take action on whether somebody is sheriff or constable. If you are constitutionally elected, county gets to make those decisions. Whether you're acting under license is different than whether you maintain your job. I mean, we frequently do suspensions, and agencies might keep somebody on in some kind of administrative position. This is just your ability to act under the license. It's not, TCOLE's not telling people employment decisions.
Thank you. Sir, if you please come up and state your name and your relationship to the case.
Good afternoon. My name is Robert Beltran. I'm a constable, Hudspeth County, Precinct 2. Good afternoon, commissioners. The reason I'm here is to disagree with Mr. Duncan's or the TCOLE findings of illegal or dangerous technique that was deployed on the subject. There is video of this incident. I have a standstill picture of the technique that I deployed on the subject. At no point is there an illegal technique. I don't know if Mr. Duncan was able to see the video, watch the video, see the standstill pictures. But in order for it to be an illegal technique or danger to the subject, I believe he's stating a House Bill 3712, which is illegal chokeholds and carotid holes that are no longer allowed by TCOLE. In order for that to take place, there had to have been constriction on the carotid areas, which at no time was there any constriction of the carotid area. The subject did not lose, or there was no impeding of breath on the subject. In order for that to happen, circulation of blood, of oxygen, had to have been stopped or ceased. None of that happened. So I'm asking that the TCOLE reconsider my suspension, looking at the facts that there was no illegal chokehold or danger to the community or to the subject at all whatsoever. That's pretty much where I'm at.
Does anyone have any questions?
May I do a brief rebuttal?
Yes, sir.
And this is just a reminder, as a summary suspension case, we don't have the facts. They haven't finished. I don't even know if they finished the criminal investigation. We don't know the status of that, right? These are cases where we are doing a very short-term suspension until the criminal disposition because of the nature of the offense. These are very limited offenses. We don't do this often. These are felony charges. He was indicted by a grand jury. So we're not arguing the facts of the case. We have an offense that rises to the level where we want to let the criminal court decide what happened, and then we would need to take further action based on the merits. But we didn't argue the merits at the hearing. As you noticed from the PFD, the judge didn't get into the merits of what happened. That's for the criminal courts to decide. This is just a case that meets our summary suspension rule.
And Mark, the threshold for initiation of an action is not, it's an arrest or indictment for a felony offense, which means it's either assaultive or sexual in nature, correct?
And the immediate peril, actually, yeah, we have some a non-enumerated list, but it's theft by a public servant, felony, assault, as mentioned. It's not even all felonies. Yeah, it is things that we believe if this happens to somebody with a license, we need to take immediate action.
I've got a question for council. With the constable position being a constitutionally elected position and then the license being separate from that, what's the daylight and what the constable can do with or without a license and holding the office?
That's a great question, and Commissioner Harvey, it's one we get all the time, and I'm going to give an answer as it relates to what they can do under 1701, and without encroaching too much on advice that a county or district attorney may give a respective constable or sheriff in this position, I will give you the licensing perspective. As Mark was talking about, a constitutional elected official, while their license may be suspended, number one, they still hold the office until removed under a quo warranto proceeding or other proceeding, either county district attorney, office of the attorney general, etc. They hold the office and have all the authority and powers that go along with it until they are removed from that office. We are simply removing because all those authorities go with the office. That is TCOLE's position legally. We are just removing their license. It is obviously for any other, whether it's a municipal chief of police, patrolman anywhere else, deputy sheriff, anywhere else in the state, this particular action, if a licensee is arrested or indicted for the type of felonies that Mark was talking about, then they're suspended, and then obviously they are off the street, unappointed, whatever the case may be. But that's a good question as it relates to constitutional elected office. Did that answer your question?
Sort of, I guess a little more granular. I suspect he can still, make assignments for, these people are in this division, or this is the policy of the office this way, but can he put handcuffs on somebody, if he were to go out on the street? And that's kind of the daylight I'm trying to get at.
I think certainly some of those questions are certainly left to the county and district attorney, how they want to direct with what they feel that the extent of what a constable's duties are, even without the peace officer license. I will give you a good background and context for that. The law as it was previously, it was 270 days until a constable. The law does contemplate a constable operating to some extent without a license by virtue of holding the office. For instance, they have 270 days, and certainly I know Commissioner West hopefully will correct me if I'm wrong here. They have 270 days to gather a license if they don't have one when they're elected. At one time, sheriffs were 2 years. So the virtue of holding the constitutional elected office speaks a great deal to the powers and authority that that person has by just simply holding the office.
Okay, I think I understand. Thank you.
Okay, any other comments or questions? Okay, do we have a motion? Yes, sir.
So basically, my disagreement is the term that I'm a peril to the community. So that just doesn't stand well, and I'm against that, and especially being it's an indictment, and especially showing the evidence that I have. I find that doesn't hold any merit, and I just basically stand against what Mr. Duncan's saying here.
Thank you, sir. Any other questions or comments?
We're not here to try your case, but you're going to have to take care of that in the county, your county. Based on what has transpired with your indictment, we, as TCOLE, under the rules, we are bound to take care of that no matter what happened in your case. That's the deal. Any peace officer, state of Texas, gets indicted. It don't matter if it's a constable, police officer, deputy sheriff. They get indicted. Their license are either going to be suspended or revoked or whatever. I mean, that's the deal. You're going to have to fight your case in Hutchinson County or wherever it is, and then hopefully you can beat that case and then hopefully get your license back. But as far as TCOLE is doing what they are bound to do by law, and that's what's happening here.
Do we have a motion?
Make the motion that we move and accept the executive director's proposal for suspension of Constable Robert Belton's license.
Second.
We have a motion and a second.
Commissioner Kim Lamo.
Aye.
Commissioner Justin West.
Aye.
Commissioner Patricia Burris.
Aye.
Commissioner Michael Griffiths.
Aye.
Commissioner Justin Berry.
Aye.
Commissioner Connor Harvey. Motion passes.
Madam Chair, ma'am. Mark, did you and counsel for the next item on the agenda. Did you have an opportunity to speak before the meeting today?
I'm going to interrupt you, sir, for just a second. Constable, I wanted to thank you for being here today and for taking the time to be here. I think we're all, especially given our service here on this commission, but also serving the public. I think we're all very respectful, when people do exercise their rights. And so we do appreciate you taking the time to be here today. We did hear what you said. We're just, I think, maybe a little misunderstanding of what our role is at this point, but we do appreciate you being here and wish you safe travels home, sir. Yes, thank you. Yeah. And I'm sorry, Counsel, I didn't mean to interrupt you or your thoughts there.
No, thank you, Madam Chair. I just want to make sure, I know I had a brief discussion with opposing counsel on this and Executive Director's Counsel to make sure you had an opportunity to speak, make sure there's ready to move forward with the case.
Yes, that Chief Null and his counsel are here. They will present after me. So, following a complaint against Robert Null about Savoy PD self-reporting training rosters, TCOLE Sergeant Dan Morales investigated and found that respondent had failed to maintain and record self-reported training as required by TCOLE rules. This resulted in the removal of 480 training credit hours from respondent's service history, as well as this action seeking to suspend respondent's license. As Chief of Savoy PD, Robert Null was responsible for maintaining and submitting to TCOLE records of continuing education for training provided by his agency. That internal training is required to have lesson plans as evidence that was properly provided. TCOLE defines lesson plan as a plan of action consisting of a sequence of logically linked topics that together make positive learning experiences. Elements of a lesson plan include measurable goals and objectives, content, a description of instructional methods, tests and activities, assessments and evaluations, and technologies utilized. Instead of all those required parts of a lesson plan, respondent maintained, and indeed had only ever created, extremely short outlines to justify hundreds of hours of training credit. After reviewing all of the evidence, the ALJ found that a one-page outline for a 100-hour basic police supervision course did not constitute a lesson plan as required by TCOLE rules. The ALJ also found that respondent failed to maintain sufficient documentation for field training course that he submitted to TCOLE. Respondent's license was already on probated suspension for DWI at the time of these violations. Violation of these continuing education rules is also a violation of his probated suspension. As such, staff recommends acceptance of the PFD and a 2-year suspension of respondent's peace officer license.
And gentlemen, I'm assuming you are here to speak related to this case. If you could please state your name and your relationship to the case, please.
Casey, there we go. Benjamin Casey. I am a staff attorney with Cleat, and I represent Robert Knoll in this matter. I'm going to speak briefly first, and then I'm going to hand the mic over to him, if that's okay with you guys. First of all, I don't want anybody to misconstrue anything I say. I recognize the importance of the training standards and the documentation for that. So if anything may come out of my mouth where you go, well, he's kind of downplaying this, that is not my intention at all. I can assure you of that. We don't take much issue with the ruling of the ALJ. Noel can speak to this, but, you know, we sat in this hearing for several hours, and I think, Mark, you can attest to that. And I think most of it was us arguing over the definition of lesson plans. So I don't want to do that again. I'm still exhausted from that. I will say this, though. Originally, the allegations involved false documentation, which the ALJ did not find. The investigation involved several more courses. The ALJ found that there were only deficient documentation submitted for 2 of those. I think the biggest thing we argued in the case was there is an outline, there is sort of a definition of a lesson plan, and TCOLE submitted as evidence an example of what they consider a lesson plan, but even the investigator under oath testified that that was preferred, but not a requirement under any of the rules. So it's not as if Noel didn't submit any documentation. He did. He now, and he'll tell you, would admit that it probably is deficient. I don't think he had a whole lot of training at the time. He doesn't do any of those things anymore. He doesn't act as a trainer. He doesn't submit any of the documentation. The real sticking point for us, though, is that, yeah, he was on probation, as Mr. Duncan accurately pointed out, but several of you have made comments about consistency and about educating officers and agencies and wanting them to do better, and this idea of sending out warnings and things. None of that happened in Chief Noel's case. Nobody looked at those documents and said, hey, Chief, look, I get what you're trying to do here, but you need more. You know, I understand that the buck stops with him. No one ever did that. No one ever warned him. He didn't really have an extensive history of submitting these documentations and probably didn't have much training either. Again, he can speak to that. But going back to it, I mean, we're talking about suspending his license for 2 years. And I'm not relitigating any of the other cases before us, but we heard you guys voted on these, that deals were cut with a sheriff for very similar things, withholding information. He got a probated suspension. False training report got 30 days. False training report got 6 months. Another sheriff got backdated, probated suspension and whatever. I mean, the punishment of 2 year suspension seems a little heavy-handed. And this is where I come in. I'm not discrediting or discounting the importance of the training documentation, but 2 years seems a little heavy-handed for something that really, you know, this doesn't rise to the level of withholding information or criminal activity or falsifying anything. It wasn't found to be liable for anything. So what we're asking is we'll take the 2 years on a probated, under a probated circumstance. That's what we were asking for. I had filed exceptions with the ALJ. He denied them. I had filed exceptions with TCOLE and did not hear back. But Chief Noel will accept the 2 years, but what we're asking is for that to be probated. In other words, extend his probation, but don't take his license away for 2 years, please. Chief Noel?
I would like to speak on my previous probation, because that's what the first thing that comes up is you're on probation. I got a DWI 11 years ago, almost 11 years ago. Horrible place in my life, making very bad decisions. Since then, I was able to turn my life around, do a lot of good things. And I'd like to continue to do those good things. And I'd like to continue to have my job, to be able to support my family, have my livelihood. I was like within a year of completing that 10-year suspension that had 8 years probated when all of this began. So that's what I ask. I learned a lot through this, a whole lot. I'm not discrediting anything. I understand this is important to keep the integrity of the training. I just ask that I continue to be able to work and support my family.
Do we have any questions or comments at this point?
I've got a few questions, but was Mark, were you going to do a rebuttal? I saw you grab the mic.
Yeah, if I could do a brief rebuttal, that'd be appreciated. If you've looked at the complaint and the PFD, I think they point out there wasn't an untruthfulness here. We did allege that. There are a lot of hours here with very minimal documentation. We did believe that this could be fraud as well, and I will point out the judge didn't find that, so that's part of the reason I think the judge did 2 years. We asked for a lot more, but we did take it very seriously. These are, I think, during the unit about 1,000 hours were done by Chief Noel and his officer Shook at the time, and what our rule says is that you have lesson plans or you have a roster and certificate, and it's the or is because you use a lot of third parties, right? And if you use a third party, they're going to give you a roster and certificate to prove it was done, and they're going to have lesson plans. And what I learned, I didn't know a lot about our lesson plans, and what people do is that we have really long documentation. We have 80 pages. An instructor should be able to look at a lesson plan and say, this is how I teach a course. And they should have tests. They should have ways to assess it. we seem to take training very seriously, but as we heard earlier, we don't always have explicit rules talking about what that is. Well, we did define lesson plan here. A chief has to have, if you're doing your internal training, you can't just do a certificate. You have to have a lesson plan showing you gave that training. And these were one-page outlines. This was here's the 8 things I taught, and I taught it over the period of a year, and I don't have any documentation, any paperwork I did, any tests. I can't remember what days it happened. The hearing got very detailed about just please give us something else. How do you even know which days you taught or how many hours you did when you have this one page to justify hundreds of hours of training? And you can see from the judge's finding that even the judge didn't know where to draw the line. They wound up saying these 100-hour courses clearly were not, this outline didn't meet the standard for the lesson plan, but then wasn't sure on the others and did not give us those. So what you're looking at, what you're bound by this finding of fact is it is the 2 courses, the 260 hours on field training and basic police officer, where a one-page outline was submitted as a lesson plan. Not fraudulently, it wasn't found to be untruthful, but our rules require chiefs to maintain that documentation, and our rules require chiefs to submit accurate documentation when they do that. We looked at it and did not think that showed that this training even happened. So I do think 2 years is appropriate in this case and would agree with the ALJ's finding.
So from TCOLE's view, these did not constitute lesson plans, or is it ambiguous?
The judge's finding was that on the 2 largest courses that these could not be construed to be lesson plans because it's just not enough information. On the shorter courses where there was also a similar plan, the judge could imagine maybe you could teach, an 8-hour shooting class without a fully detailed lesson plan.
Right. So findings of fact 15 and 20 say they're not lesson plans, and we're bound by that. So I guess for your friend on the other side, what do we do with that then? Because you kind of started off with, it's kind of ambiguous whether these are lesson plans, but if we're bound by the findings 15 and 20, then do we have any room to do anything with that? That's for both of you.
Yeah, those were the violations of rule, and I like to categorize that because that was kind of what happened earlier, right? We have to stick to what the judge says for findings of fact. I'm not asking you to flip any rules, any legal conclusions here. Those 2 were found not to have lesson plans. So it's a documentation issue about having the evidence to show you gave the training that you submitted as chief.
And I guess, and this, and can you, if the other side has a response to that as well, I kind of want to hear their answer.
Well, obviously, I disagree with those findings of fact. I think that was, if you read through the ALJ's opinion, he keeps using the word deficient. So it's not like documentation wasn't submitted. And I still maintain that the way that the rule is worded does leave some ambiguity in it. And we argued back and forth with that. Obviously, Mr. Duncan and I disagree. I disagree with the ALJ's ruling. Documentation was submitted, but the ALJ found that it was deficient. I don't agree with that. The other thing I think you stated is that you guys are bound by those findings of fact. I'm not sure that's the case, that you're bound by that proposal for a decision. Anyway, correct me if I'm wrong, but isn't that a proposal? You guys can decide what you want to decide at the end of the day on that proposal. So my understanding is that you're not bound by those findings of fact. They are on that paper, but you don't have to do what the ALJ proposes.
I think we're bound by the findings.
To respond to that, we will take our guidance from our general counsel on that. So I just want to make that clear.
Yeah. And John, if you want to weigh in, my understanding is we're bound by the findings of fact, but not the conclusions of law.
Love to. As a general proposition, your findings of fact, the ALJ is deferred to both in statute and as practice, as you've seen in our orders that we've provided to you all regarding what the ALJ's and SOA's jurisdiction is, both in previous cases. This goes back to our discussion earlier. The ALJ's primary duty is being the finder of fact because they are there to observe the witness, weigh the witness's testimony, everything that goes along with it. Now, where you as a commission, where your great discretion lay is with determining the appropriate sanction as it relates to a set of factual findings. Now, if you have a finding of fact that is technically incorrect, we saw an example of that earlier today. I think it was Mr. Heath. It was one of the agreed, or excuse me, it was one of the earlier PFDs, wherever it was in the agenda. It was a discussion of a technical finding of fact, which we corrected. Now, where you say cancellation versus you say revocation, that may not have been the specific one, but that's the example I'm using for the purpose of our discussion. Now, let's talk about going back to findings of fact. You see them unless there is a technically incorrect or certainly not applicable in this case. There are some cases where you can look into the findings of fact, but nonetheless, the ALJ is the ultimate determination of the finders of fact. The conclusions of law, specifically those that relate to a recommended sanction, that is where the commission's discretion lay, assuming that's within the bounds of what your statutory and your regulatory authority are. You have been based on all of your previous decisions and underneath the rules, your range of sanction that is available in a particular case.
So with findings 15 and 20, it says failed to contain lessons plan or failed to have a lesson plan. And it's just so I'm clear, were documents submitted? It's just the ALJ said those are not qualifying as lesson plans for those 15 and 20?
Correct. The chief is also required as chief administrative duties to maintain lesson plans for the courses that you've submitted. So he submits the rosters to us. We don't see the lesson plan when it's submitted.
Yeah, those kind of seem like conclusions of law, not really findings of fact to me, whether something is or is not a lesson plan.
I agree with that. There is some, if we believe they got the law wrong, we could try to flip it. As we've occasionally done, we can't do that with findings of fact. And a lesson plan is under our definition. I read how we define it, but in this case, we're not asking to flip any conclusions of law.
And then my other question, separate from that, and I'd like to hear from both sides on this as well, is how does this 2-year suspension, I know it was mentioned earlier about other sanctions and things given to in other situations, but how does this compound with the earlier suspension, and where facts like that and the other cases mentioned earlier where lesser suspensions were given or probated suspensions? What's our practice there typically, and what's the, I assume that's part of this is the compounding effect of the earlier suspension, but could you both speak to that and how it maybe compares to similar cases?
You have a lot of discretion on sanction, as just mentioned. How much you want to weigh a violation while you're on probated suspension. The agreement that you sign or the orders that you're given for probated suspension includes a statement that you can't violate any other TCOLE policies. How much you want to weigh that, of course, is within your discretion, but it's, and then how much the amount of hours at play here matters, or this particular violation.
Right. But does that weigh into, how does that weigh into your recommendation? I know we have discretion, but for you all recommending that we accept it, how does it weigh into your recommendation?
I think the violating probated suspension was part of 2 years. 2 years is a significant suspension.
Commissioner Harvey, I'm sorry, I'll just make a commentary that's outside of the specifics of, I would certainly say that a probated suspension in and of itself could be a 10-year suspension. In and of itself, it could be a 10-year disqualifier. I think, again, not speaking for Mr. Duncan or the executive director, I will certainly say, again, going back to at least my observations in cases that are brought before you all, certainly the primary most aggravating circumstance, or at least one that would rebut or completely work against any mitigating factors, would be the fact that you were under a probated suspension, either one, conditions of probation, one of which is not to violate any commission laws. That is certainly a big distinction between this case and many others, because you have, again, a singular act in violation of rules as it relates to criminal misconduct, which in of itself could have been, as we've seen on our own agenda today, could result in a 10-year suspension.
That's a very good point. This does come close to the amount of time left on the probated suspension. So that is often what we might settle for in a case where a violation comes during a probated suspension.
Okay. And Mr. Casey, do you have any responses to those questions?
Well, the first thing I want to point out is that a probated suspension is still a suspension. Under that discretion, you could have a probated sentence for Chief Knoll of 4 years or 5 years, whatever you choose to do. Yes, an ALJ found that there was technically a rule violation while he was on probation for an earlier criminal act. That is true. However, I want to go back to this idea of, this education. We want to educate the agencies. We want to help them succeed. We want to make sure all these things are done, talked about warnings. Again, none of that happened here. I don't like the kind of message that this sends on something like this where, and I think you were correct for what it's worth to point out that those findings of fact do read as conclusions of law, because obviously he's taking whatever definition of lesson plans in the rules and looking at documentation and making a decision as to whether or not that complies with that rule. That, to me, is a conclusion of law as well. And so in that vein, I would say that, we got to look at the severity of these as well. I mean, it's not like he didn't submit anything. It's not like he slammed the door on the investigators and didn't return their phone calls. He sat there for several hours going through his documentation. He didn't hide anything. There was one, I think for one class, he didn't turn anything or didn't have anything because he couldn't find it that day. But my understanding was that the sergeant that was investigating never showed back up. But again, I think it's about the severity. I think it's about the message it sends. If we're going to take his license away for 2 years and he can't practice because he submitted documentation that an ALJ said, well, I don't necessarily think that meets the definition of a lesson plan, so we'll take it away for 2 years. And that's pretty harsh in a situation where I think TCOLE could have come back to him and said, hey, you've got to do better than this. We need more documentation. I mean, they have the power to do that and say, okay, well, what do you mean? Well, this is what we mean. This is what the definition in our mind is. And here's an example of it. So why don't you redo these and resubmit these? That could have happened, but it did not. So again, we are asking, I mean, whatever you want to give him, I would ask that it be probated, whatever length that you would like. Yes, sir.
I've got a few comments and questions as well, probably for legal and for you as well.
Okay.
I view this case probably from a different lens than probably my colleagues do, because he's on probation for an alcohol-related offense. How many years ago was that?
January, it'd have been January of 2015, so
15,
almost
about
11 years ago.
Yeah, 10, 11 years ago. This isn't about you having a relapse or alcohol issues or things of that nature. I do think there's a concern that you are on probation and we have a rule violation, so that I do think there's a mitigating factor there. When I first read this, I also had initial concerns. I was like, did he just try to defraud us with his training stuff? But reading the ALR judge's case, looking through this, hearing the totality of what my colleagues are saying, what y'all are saying, I think you're just a bad instructor, man, if I'm going to be quite blunt with it. And I'm looking at your record. You went through the basic instructor proficiency course. I'm in the belief that this is an issue with your ability to be an instructor more than your issue with a license. This is where I'm at with this. I'm under the mind to see, and this is my question for legal is, are we able to suspend his instructor license, his instructor certificate? Is that on the table?
I would ask, Mr. Duncan, is the instructor license, do we have a valid instructor license, if hypothetically speaking, to suspend?
I'm just looking at
take
it.
away?
Yeah.
Good to go?
I'm looking at this. I would like to hear the answer.
Yes, he did obtain that. In fact, it was going to be part of my rebuttal to that last comment. We, at one point, he did become an instructor, go through the course and continue to submit this kind of documentation for maybe the last course or two at evidence here.
Yeah, no, and I think I'm of the mind, and I'm kind of toying through as I hear more from my colleagues as well. I'm of the mind that's what the issue is at. That's a certificate that I don't think you deserve to keep. I don't think you're handling it properly. I think you've egregiously made some issues in that area of ways, for sure. But I'm going to let the rest of my colleagues speak as I hear from them. But that's kind of where my mind is at, is I think this is you're just a bad instructor, man.
And Commissioner Berry, so I'm clear, give you the answer that I hope will answer your question. Yes, you can. That goes back to that discretion to, if that's the sanction for which is proposed, that is a option for sanction.
And if I may point something out, Director Grisham may be able to clarify this. He wasn't in violation of teaching courses without an instructor certificate as chief. So chiefs are still able to, is my understanding, and instruct courses and submit training that they do internally. So he would still be able to do that as chief, but I do agree you would have
No,
discretion to do that.
that's a great point then. Do we have the means to, under our terms, if we wanted to, make him retake an instructor course at a credible institution to relearn his duties?
And it goes back with the sanction as well. Yes, you can impose reasonable terms of probation upon a licensee.
Thank you.
Director Stevens.
Yes, ma'am.
What are your thoughts, sir?
When we reviewed this case, it was apparent that they were training each other and logging a lot of hours that we believe did not occur.
Were we able to prove that with the ALR judge?
Something I mentioned earlier. We did assert untruthful submissions to TCOLE via these rosters, and the judge did not find that. So this was determined to be a lack of paperwork and not a fraud issue.
Okay, I'm going to ask specifically about Mr. Casey mentioning that we could have come back and said, bring us to paperwork, do this, do that. During the SOA hearing, was it ever thought, rather than being asked to bring additional paperwork, that you guys would produce those additional, this is to the other side. If you were to produce those documents that you keep telling us we should have told you to, hey, go redo your documents, you bring those to ALJ to say, hey, here's actually, we do have better documentation. We just had bad stuff before.
I'm most
To him.
Oh, sure.
Well, at that point during the hearing, when we were still making the argument that the documentation he submitted did meet the definition of it, technically met the definition of it. So at that point, we weren't of the opinion that we needed to supplement any of those because we still stood by that, you know, arguing before the ALJ that those were sufficient, looking at the definition. That was my legal opinion, and that was why I was arguing with that. So no, that's a good point. But at that point in time, the thinking was not, well, why don't we bring the, we didn't know at that time, honestly. We knew what the allegations were, but we didn't know at that time, okay, well, if these are deficient, what is not deficient? That's what I meant when I said at the time that they got the documentation from in the first place, looking at them and saying, whoa, Bub, this is, what do you got? What did you just give me? This is weak. This is one page. Come on. You know, something like that. Because I know that happens. TCOLE has field reps that I advise my clients all the time to call if they have any specific questions, to call and get that information. And so I don't know if you reached out to a field rep. I believe that you testified that you did, but I don't want to get too far down that.
No, that's fine.
Down that line.
So that's my point, though. Yeah, as TCOLE, again, we want minimum standards, we want compliance, all that. We should be helping, but there are 100 and something thousand licensees and a handful of field reps. So we're not always going to be able to meet that standard. So your advice to your client is, yeah, you should do better, reach out and do whatever. When you did your exceptions back to LJ, did you say, hey, well, we can produce better documents? Or when you spoke with counsel, could we provide you better documents? Rather than asking TCOLE to say, hey, make better documents after they've told you these are deficient. Was there ever a point that you discussed with your client or discussed internally, hey, let's try to produce something better. Maybe that will meet their.
Not at that point, because my exceptions weren't about the ALJ's findings. I knew that it was what it was. He read the law a certain way. I read it a different way. We lost. My exception here today is the severity of the punishment that's proposed, not relitigating, you know, whether or not they met the definition of the lesson plan. I'm at least going to go through Christmas thinking that they did, but that's my job. But that's not what I'm here arguing today. Today is all about the punishment and asking to use your discretion and maybe not, you know, hit his whole career with a sledgehammer.
I've got a follow-up question for y'all as well as our executive director. Now, the other person was the Sheriff Shook that we took action on earlier today because I saw his name on the list, and we gave him a 6-month probated suspension. and I'm assuming it's related to very similar things.
That was also my case, so I could speak a little bit to it, but they are different facts. Obviously, you can see from this PFD that the chief administrator has responsibilities as chief administrator. And because Chief Null was submitting most of these, it was slightly different facts between the two cases. They are very similar.
Yeah, but both ought to have known if they were in the wrong doing what they were doing.
That is certainly staff's argument, yes.
I'll say also that in my determination in what to recommend and what to agree to and not, answer for our question that was asked earlier, I do take into account previous TCOLE disciplinary history, and the sheriff was not on probation at that time, and I don't believe, and correct me if I'm wrong, if we need to look that up, I don't believe the sheriff had previous TCOLE history in terms of discipline. It's been a little while, but I don't believe he did. But he certainly was not on probation. His license was not under probation at the time. Yes, sir.
I think that's prudent wisdom on your part. And my other question is for Chief Noel. Do y'all have a training coordinator at your agency?
At that time, that was my responsibility as chief. I have since, prior to this hearing, I have stepped down. I'm no longer chief there. I have no desire to go back into chief administration, no desire to go back into being an instructor or anything to do with reporting training or anything like that. I want to go back to doing my job as a peace officer and let other people worry about all the paperwork side of things.
So you're no longer the chief and you have no intention of being the chief. So therefore, as not a chief, you can't sign up on training.
I cannot sign up on training anymore, sir.
Thank you.
This one's for council. If we wanted to discuss possible other, I guess, sanctions or remedies, is that something we can meet privately with you to do briefly?
Excuse me, it would have to be we would do an open meeting.
Okay.
Yeah. Do you have any specific questions that I can answer about that right now?
No, it's just something that doesn't happen very often. So I was curious about the full options we have.
And I'll give you the generic rundown. When maybe talking this may stimulate some questions you may have or commentary from the other commissioners. You can go all the way, basically from a reprimand all the way up to the full suspension that's requested. That's the general outline. But I think, and I'm going to gather from some of the commentary and questions you all have had, there is number one. I know Commissioner Berry talked about perhaps an action against the instructor certificate. I know there was just some talk about, I know Chief just spoke about no longer desiring to be a chief administrator or no longer being able to sign off on training. I'm not advocating for those necessarily, but I am saying that those are options or discussion points if you want to think about those types of, this is the type of circumstances or conditions we would want to see as a commission in this particular case that both fits and is warranted by the findings of fact and the conclusions of law. Now you have a couple options. It's something we can kind of discuss through right now, or it's something that I'm going to, again, it's my job to give you all the continuum of options here. This is something that could be sent back to staff to come up with a list of conditions or conditions precedent, conditions of probation, whatever the case is, that we can bring back to you in February along the lines of things you've discussed today. That's certainly a possibility in the form of an agreed order, but we would need some general guidance as to we don't want a suspension. We don't want a probated suspension or whatever mixture, blend, combination of probation, suspension, no probation, no suspension, whatever the case may be. But I think we could get general direction and bring to you all back a list of conditions which you may feel comfortable with proceeding on based on the facts that you have before you.
I think, and maybe my fellow commissioners would disagree and want to move forward today, but I think it might be worthwhile for both sides to maybe talk about something in between. From my view, I think I agree with Commissioner Berry that you're probably a bad trainer. And so if you're, a restriction on being chief administrator, perhaps, a restriction on not providing any more training, perhaps. But that's only prospectively looking, and I do think that some punishment is warranted. I'm not sure if it's the full suspension like recommended today, but I don't think it would be just those restrictions prospectively with nothing retrospective as well.
I think
I'm going to make a couple of comments as a chief administrator. Actually, I'm going to back up a little bit. Did you ever write a traffic citation? Have you ever written one?
Yes, ma'am.
Okay. When we write a traffic citation, we are under the understanding that when you go get a license, you are responsible for all, 1,000 pages of the traffic code. And knowing that and understanding that and following all of the directives within that code. Now, do most people do that? The reality of it is no. But at the end of the day, we issue citations to people with that premise and understanding is that they know that they violated that rule or law, and that's part of the privilege of being granted a license. And I'm going to leap forward to becoming a chief administrator. There are a lot of resources in the state for chief administrators, whether you're an administrator of a department of 1 or 2, or, you are a department of 5,000. And that comes, from counterparts, from peers. There's 2 different classes that we have to go through with LEMIT. We've got our TCOLE field agents. But I guess at the end of the day, my opinion as a chief administrator is when you take on that role and that responsibility, if you don't know something, you have a duty and an obligation to understand what the rules are, what the requirements are, but also you set the standard, and I'm having a hard time comprehending just the common sense component of not understanding what would qualify as a lesson plan, and that a list of people and, 1-page list of people and what classes doesn't constitute that. I mean, we go through training. You went through the academy. Instructors reference the lesson plans all day, every day. They talk about the learning objectives. I mean, that's pretty standard. You come in and the first thing they do is talk about the learning objectives and the lesson plans. And you're the chief administrator. You set the standard. You accepted that job. You accepted the responsibility. You set the standard for your agency, and really put yourself in a position of, and I get we're not talking about this, but you've put yourself in a position where people have questioned, did you really do those training classes? Because we have people across the state that falsify training records. We know that. We can't tell you for sure whether you did or you didn't falsify those training records. I don't know whether you did or you didn't. It's not a finding of fact in that case, but I'm still not 100% sure you didn't. You're the chief administrator, but you're not acting like a chief administrator. You talked about not acting like an instructor. I'm going to take it a step further. You want the title, you want the pay, you want that position, but you got to play the part, and you owe that to the profession, you owe that to your department, you owe that to your city, you owe that to the men and women that work for you. And I don't see that you did that. And I hope you didn't falsify records, because if you did, the position that you put your team, the people that worked for you in, I won't even go there. But you certainly haven't done this profession justice by your actions. And I don't understand how that would have been acceptable to you to not do a better job. That's what I have to say.
I will, I echo her sentiments completely. The fact that you just acknowledged that you stepped down as the chief administrator speaks volumes. I'm glad you did that because, like I said, to Chief Lamo's point, as we told that guy, the buck stops somewhere, right?
Yes, sir.
I'm going to make a motion. We'll see my colleagues where they're at with it, but.
Oh, hold on.
Oh, yes, ma'am. Sorry.
Before you make a motion, do we have any other questions, comments?
I have a comment since I guess I'm probably the only one that hasn't spoken yet on it. I would echo the presiding officer's comments. I think that, I know this is what's been determined by the ALJ, and I mean, we read the packets, we read everything in there as well. A failure to contain lesson plans outlines for a 160-hour course, failure to contain lesson plans for a 100-hour, 1-year course are violations of the TAC. When you add that to violating a probated suspension, if you were a person under criminal suspension and you violated the conditions, you could very well find yourself in jail. And so I would say having your license taken away can be akin to that. No one so far, as I've heard today, is saying your license should be taken away from you indefinitely. But there is a punishment that is necessary. And we don't check our common sense at the door when we come here. Like I said, we read the whole thing. I think it's clear from the ALJ's writing and conclusions that the ALJ also did not check her common sense at the door. These are I'm trying to go back to the portion in here. In the PFD, she said a she, I'm saying she, I don't remember. But states, the ALJ further finds it's implausible, which I completely agree with that. It is implausible that the respondent or anyone else for that matter would have been able to instruct a 160-hour course without a scrap of notes or any semblance of lesson plan. We look at this with the totality of the circumstances. It's clear to me that's also what the ALJ did here. And I think a 2-year suspension is very fair. I don't believe anything less than that is merited. I could probably be convinced to go higher than that, but given that it seems like everyone's landed on this number, I feel comfortable with that number. That's all I have.
Any other comments or questions?
And I may ask for help from General Counsel as I phrase out my motion here. It's a little complex. My goal with this motion is to get to the root of the issue. I think a 2-year suspension, you can come right back and cause same problems again. So I move that we suspend the basic instructor certificate, the firearms instructor certificate for 10 years with the condition that Robert Knoll is suspended from serving as a chief administrator for 10 years and a 2-year probated license suspension, a 2-year license suspension that is probated, if I'm making that make sense, basically probate a license suspension for 2 years that is probated.
Madam Chair, may I? Commissioner Berry, could you say again that list so everyone is absolutely clear on what your motion is?
Yes.
Including me.
So my intent is this. Let me start with my intent and then see if we can help phrase it better. I intend that we suspend Robert Knoll's basic instructor certificate, his firearms instructor certificate for 10 years.
Gotcha.
My intent is that he is suspended from serving as a chief administrator for 10 years. And I further that we do to acknowledge the fact that he was currently on probation with a licensure or license issue, that we do a 2-year probated suspension on his license, so that's probated.
Is there anything else, Commissioner Berry, on your proposed motion?
No, that's the intent of my motion.
I'm going to read back to you. The 10-year suspension of the instructor and basic firearms instructor certificates. The 10-year prohibition against being a chief administrator. And a 2-year suspension fully probated, a 2-year probated suspension. Is that accurate?
Yes, sir.
Am I able to amend the motion? I would amend it so that it is a 1-year suspension with a 1-year probated suspension.
The motion before you, Commissioners, was the 10-year suspension of the instructor and basic firearms course certificates, 10-year no chief administration, no being a chief administrator, and a 1-year suspension followed by a 1-year probated suspension for your consideration.
And that suspension is from today, not from the findings.
Unless otherwise noted or amended, yes, it would be from date of entry, which would be today. Yes, sir.
So a 1-year suspension, I mean, in addition to the instructor certificates, 1-year full suspension, and then 1-year probated suspension.
That's correct. That's the amended motion.
If there's no second on that, then I am open to your option earlier. If there's no second on this, then I am open to what you offered earlier, but I'll let everyone have a moment to think too. Yeah.
That would be my recommendation, Madam Chair, to see if there's a second on the original Commissioner Berry motion and proceed forward from there.
Do we have a second to Commissioner Berry's motion?
Second.
Okay. We have a motion and a second. We'll do a roll call vote.
Well, just to be sure, because I might, right, not vote for this one because I prefer mine, and that's why I thought amending it, that going backwards might be the
Okay.
better way to handle it.
Okay, and Counselor, you can stop me or correct me here. Commissioner Berry, would you accept the amendment and change your original one to encompass and incorporate the amendment? And you don't have to, I'm just asking you yes or no. And if so, please restate your motion. Does that cover that, Counselor?
We can try it that way. See what Commissioner Berry says.
I do accept the motion to amend it. So I move to suspend the instructor certificate, firearms certificate for 10 years with the condition that Robert Knoll is suspended from serving as a chief administrator for 10 years, with a 1-year suspension on his license, followed by a 1-year probated suspension.
Okay, we have a motion and we have a second.
Commissioner Kim Lamo,
No.
Commissioner Justin West, Commissioner Patricia Burris,
Nay.
Commissioner Michael Griffiths, Commissioner Justin Barry, Commissioner Connor Harvey. 2 nays, 4 ayes, motion passes.
And I do have, just for a clarification point, Counselor, on the portion of it of not being able to hold a chief administrator license for that period of time, if he were to accept a position, then that would nullify his license, or what would that look like?
I don't, and this is just me speaking my initial impression of what your question is. I would not say that my initial thought is not accepting a chief administrative position in and of itself may not necessarily be a violation, which would trigger a cascading series of consequences that would act on his license. I do think it would be more preventative from agency staff to ensure that we would not accept or ensure that there would be no L1 would allow this person to be a chief administrator. That's where I think it would come from, that end. But that's, again, just my initial approach, and I'm sure someone on staff is probably has a much better as far as procedurally and the nomenclature and how to do it, but that would be my first thought.
Well, did you have a comment?
Sure. I mean, absent conditions here, it would be a new violation, and we could open a new case or something if we wished. If we missed the L1 and he became a chief,
Okay.
he would have due process rights again to challenge that.
Okay.
It would be a new action.
Okay. Well, gentlemen, as we told our other guests, thank you very much for traveling here. We heard what you said, obviously. I hope this isn't a situation where be careful what you ask for. I hope you don't walk away with that, with those thoughts and feelings, but congratulations. And good luck to you.
May I clarify something real quickly just while he's here? I think he's made clear his intent, but I don't want him to think that that he can rely on us to reject an L1. He shouldn't accept a position as an acting chief administrator, an interim chief. He shouldn't accept appointment as chief or run for office, which would make him a chief administrator. The way that would probably come to light, at least in my experience in enforcement investigations, is if we got another complaint and found he was acting as chief administrator, we would bring that as part of a new case. But he does have the responsibility to make sure that he complies with those conditions, because it's not a rule violation. We can't necessarily set the system to reject an L1 just for a chief administrator position.
Yeah, it would be compounded. Very much so. Thank you. We are going to take a 15-minute break. Okay, we are back in session. And we are going to pick up where we left off. And I believe that this is also yours, Mark.
Yeah, we adjourned with about 30 seconds left. I'll remind you that we did have an agreed order on Jose Hinojosa, so that is not a PFD to be heard today. We settled that one. So we are on to the FYI section. For the information only section, no action is required from you. We had 4 statutory suspensions, 5 statutory revocations, 2 term surrenders, 31 permanent surrenders, and 8 reprimands for administrative violations. And that is it. These actions have already taken place by statute or operation of law, so no action is needed by the commission.
Okay, we are going to move to agenda item number 6, which is to receive public comment. Do we have anyone that wishes to come forward and make public comment? I do not see anyone rushing down to the front, so I will assume that we do not. We're going to move to agenda item number 7. We are going, which is executive session. We will be going into executive session, and I am assuming that we will do general session here in this room, and that those of you that are not staying, Melissa, do we have another room where other people can go, or does it need to be out? Okay. Who shall we text? Who's going to be the keeper of everyone? Who shall we text when we're finished, or somebody will just come out and get you? John will come out and get you and let you know when we are done with general session, or executive session.
Stay out of the street.
We are now back in session. We'll move to agenda item number 9. Do we have a motion?
So moved.
We have a motion and a second. We will see everybody tomorrow morning at 9. Is that correct? 9 o'clock. Thank you. Huh? No, it's 9 o'clock.